advice do you have to homeowners?
Practicing that preparedness, starting the conversation now is always going to be a benefit to any association out there.
And welcome to Recovery Report Live. I'm Dan Odess, president of GlobalPro, where we manage risk to recovery, and we have managed more than $1 billion in recovery. But we've also helped thousands of policyholders place insurance and plan for the next event, right? We want to make sure that you have the information you can use. That's what we do here every Thursday at 11 o'clock. Thanks so much for joining us. We are live, YouTube, Facebook, and maybe even LinkedIn. We'll see following this stream if that worked for us, but we're excited to be on LinkedIn. We can't wait for those in our business community to be able to see us, whether it's working today or for the next show. We'll make sure that you have access to it, so it's a pretty exciting thing for us. Wanted to make sure that all of our viewers are listening in and know about it. Just another place for you to be able to hear about important real estate, insurance, business topics, strategy, information you can use. Whether it's, we span the gamuts of having lawyers on, to having lobbyists on, to contractors, material suppliers, manufacturers. We want to make sure that you have information you can use. And one of the things that's impacting the real estate market right now are the rising costs of materials and labor due to a lot of shortages, the supply chain issues that all of us are hearing about. If you're in the business or in the community association industry, you are absolutely hearing about these issues, whether you're planning projects, whether you're in the midst of a project. There are concerns, there are constraints, and it's causing a rise in those costs. I heard from one developer recently at a BizNow event where I had an opportunity to be a keynote speaker, spoke on issues regarding GlobalPro and what we're doing in the community, and they had a fireside chat about these issues regarding the rising costs. And one developer mentioned that in a lot of the new product contracts for the new products that are coming online, there are actually clauses in there that may allow the developers to raise the costs of the units mid-contract before delivery. Think about that, right? You thought you bought a unit at one cost, and now the cost of the goods and the services are all going up in order to deliver those products to you, those condo units, those homes and HOAs. All those costs may go up on you. It may cost you more to close on your new home, whether that's in a high-rise building or in a garden-style property or even a single-family home. Just think about those things, and if you are an investor out there that are buying units or you're in that market, in that industry, something to consider, something to think about. Wealth Management just wrote a great article, and if you get our email blast, you'll see it in there. Definitely recommend that you read this one. It talks about how these costs are being passed on to consumers and how it's impacting them. But it's not the only place that things are changing, and our next guest has a long, successful legal career with a focus on community associations. A lot of community associations are feeling the heat of a lot of changes, not only as it relates to budget seasons and insurance, but also a lot of legislative changes and obligations and changing and things. But there's this changing market, right? This hard market on insurance, the increasing cost of dealing with these things is all coming at a toll for not only privately owned single-family homeowners or business owners, but also community associations, homeowner associations. And this particular guest is located in the Texas market area, and we want to bring him on. And I'm going to bring Marc on a little bit earlier. Hey, Marc, how you doing?
Good morning.
Great to thanks so much for joining us today.
Glad to. Happy to be here.
So his firm is very well known in the Texas and assists community association managers and boards navigate the changing and difficult legal landscape. And as a full-service law firm servicing the needs of clients for community associations, corporations, litigation, and real estate law. And I'm going to give it a shot at this one, Marc. You have Roberts, Markel, Weinberg, Butler, Hailey, PC. I think I did all right there. An amazing law firm. Definitely recommend you guys check it out. At the end of this, Marc will give you guys all the contact information for it. Tell us a little bit about the firm. Tell us about the types of clients and the focus of it.
Well, the firm started back in 1980 when I was 12 years old. And we started out just as two attorneys, Roberts and Markel. That's how it started, and our names have kind of just stayed with the firm the entire time. We now have 50 attorneys and practice in 4 cities in Texas, which are the major metropolitan areas. And we represent probably about 1,600 or more community associations, condo associations, and other common interest communities. And so we have seen them all. We represent them from 3 units up to 25,000 units, and probably some that are a little bit bigger than that at this point. So they run the gamut. HOA is, I guess, about half, and condos are about half. In Texas, I don't know if you're aware, but municipalities won't allow a subdivision to be created without an HOA because they want a financial vehicle in place to be able to take care of amenities, even as low as just a signs entering the community or any other amenities. So the firm itself started out as being just general practice. And early in my career, I lived in a restricted community, and the manager at that point knew I was a lawyer and called me in and said, "Can you help us with some community association problems?" I said, "I don't know anything about it." I said, "So why don't I work for free for a few months, and we'll see if we both can't figure it out together." Well, back in 1980, there was a very little body of law dealing with this topic. And so after about a year, I think I had a dozen HOA clients, and it's blossomed from them. So it's been a pretty good run with community associations. That's primarily what I do. I have board certifications in real estate, property association law, and commercial and residential real estate. And so my practice just solely revolves around real estate. Now, our firm tries to find the best and the brightest, and most of our attorneys are board certified in at least one or more practice areas.
So tremendous amount of experience. You've been in the game for a while. I know that the Texas market well, a lot of changes there. I personally, both on the construction and the insurance side, have seen the major changes that are occurring with the urban sprawl and the what once was these sleepy little towns is suddenly an urban core, and a lot of development going on. And the big names in the development world are all in Texas now. And far outside of your Dallas and your Houstons and other in San Antonios, but and again, in these sleepy towns, starting even in major metropolitan areas. But and community association and the way that these things are up is very attractive, right? It's you go in there, you got the amenities, you have all the things kind of taken full care of you, whether it's single family home organization, and they take care of all your lawn and your roofs and your paint and things like that, to your high-rise vertical type construction. Where you have a lot of amenities and things are really tied together, right, from one unit to the next. So what do you think, though, with this changing landscape in community associations? We got coverage, we got legislation, we have the management changes that are occurring. What do you think is the biggest challenge facing community associations? Now, I know there's a lot of challenges, right? But we only have about 20 minutes to talk about this. We want to try to keep the show. Right. So let's try to pick that one big challenge, and let's dissect it a little bit that you think that's impacting community associations.
How about we limit it to three?
Got it. All right, deal. Yeah.
I think the number one has been the number one since the beginning of my practice, and that's people.
Yep.
And people, by their very nature, don't like being told what to do, but they like living in an area where their neighbors are told what to do. And so it's a constant battle, if you will, to try to maintain the integrity of the restrictions that are established for the community, when the owners always feel as though the leadership, whether it's the development team in the initial stages or the homeowner volunteers in the later stages, all are against them. Because it's like any government. People love to hate their government. And this is the most local form of government there is. So number one in my mind would be the people.
Always.
Number two is the insurance issues. And on a daily basis, I can't tell you how many calls we get from people who can't find qualified vendors to service their communities. We could talk a little bit more about that in terms of claims history, in terms of costs and things like that. But let's get to the third one. The third one is actually finding folks who are willing to work on a schedule. If your pool's going to open in May, you want your pool repairs to be finished by the end of April.
Yep.
But if they don't have workers that are willing to come out and work, you might have delayed opening of facilities and also delayed maintenance on your projects. And right now, the words deferred maintenance, which means something different to everybody, is on the tip of people's tongue as it relates to the condo associations primarily. Because now the owners who hated their boards for raising their assessments are wondering why the crack in the garage is not going to cause the building to fall down. So those would be my three large areas. And the people we can't do anything about. We can try to placate people, but at the end of the day, they chose to live there. They can come live out where I live, and there's very few restrictions, but you might have hogs living next door. But as to the insurance thing, it's shifting sands, and you probably know more about the sands on this than I do. But I do know that when we have worked with the insurance professionals to come up with an insurance schedule that we want our vendors to have, more and more of them aren't able financially to be able to afford them or obtain them if they're commercially available at all.
Yeah, and then making sure that insurance, whatever it is that they're able to even get, is compliant with bylaws and restrictions within the community association. And you and I had a little time to talk, before the show about, some examples of things that we have dealt with where, they're not able to get the aggregate limits and the per occurrence limits, and what happens if something happens and they cause damage or allegedly are the cause of the damage. And what an association is to do when they exceed those limits, and how do they get the protections if you have the few contractors that have all the jobs, have all the money, and they can't even get the insurance. Obviously, it kind of shrinks the field as far as competition for them, and then next thing you know, you're paying even more money. But again, though, that contractor at the top can't even get the insurance that your bylaws or your restrictions are requiring that they carry. And it's an interesting landscape, particularly in the wake of Surfside, right? And the tragic loss that occurred there in the South Florida community. You and I talked a little bit about this, and for Texas, again, another market outside of Florida where you mentioned some of the challenges and changes and so I want to talk a little bit about that. What are you seeing as far as possible future legislation and change in ways boards operate in the wake of that tragedy here in South Florida?
Well, the tragedy is remarkable. Okay, so we don't want to understate that in any way. But what went wrong is twofold. One is potentially not examining the structure enough frequently with the right people, okay, to find out what is wrong, what needs to be fixed immediately. And the secondary was, where was the insurance appraisal to figure out how much insurance they should have had, similar, just on the structure alone, let alone the liability insurance that they may or may not have had. And so what I wanted to talk about just for a minute is, let's go back. Why do associations enter into contract with vendors as opposed to just hiring employees? Well, it's because we want to shift our risk, right? So when we shift our risk, we hire an engineering firm to go out and analyze our building. We want them to do non-destructive and destructive testing to tell us that our building is sound, and if it isn't, where is the list of items that need to be repaired? When should they be repaired? Who should repair them? So we have some third party telling us what we should do to make our property, I hate to use the word safe, but I'm going to say make the property workable, okay? And then that company who's going to do that work comes and brings you a contract, and they have $1 million E&O with a $1 million excess policy. And in their contract, it says their damages are limited to the amount of money you paid us in the last 12 months. Now, associations by their very nature are cheap because they have homeowners telling them they don't want to pay large assessments or higher assessments. And so they put themselves in a position where they don't hire the lawyer to review the contract, and then they're bound by some crappy terms, which will put them in a bind later on. It's just like the other insurance packages that are out there where they hire a pool company. In Texas, pool companies are very, very scarce these days that have adequate insurance. And more of them, as you've alluded to, are sliding in things that are not compliant with what the association asks for, if they ask at all. Most don't. Most say, can you provide me pool maintenance, upkeep, construction, and lifeguard services? And they go, okay, fine. And do you have insurance? Yeah, we have insurance. And that's where the conversation ends. Well, if that same company is monitoring 40 pools at 40 different communities, and they have a $1 million insurance policy, how many drownings does $1 million cover? And that's not $1 million per project or per location. That's per the company for the entire year. And so associations have got to become wiser to making sure that not only do they have adequate insurance to cover liability and property loss, But they also require that of all of the vendors that they do business with, to where there's a true shifting of the risk to the vendor, or they might as well try to find somebody cheap, because why are we hiring the vendor to start with?
Right.
And more and more of those contracts are problematic for community associations. So I think they need to find professionals who are willing to be responsible for the decisions they make, and then follow the recommendations so long as they believe them to be true.
And I want to highlight something you said, because I think it's a really important takeaway, that if our audience leaves today with one little nugget, where you talked about contrasting the per occurrence and aggregate amount of insurance available, and the contract language and terms limiting coverage to the amount of the contract or whatever you've spent with them, and the conflict that creates, right? Whereas the insurance policy itself, yes, complies with the bylaws and the covenants of the association, the contract itself in its limiting language would not. So there's inherently a conflict there. And quite frankly, I've seen this in a situation where the insurance company, after paying over $8 million to the association, went back to try to subrogate against the contractor, saw this language, and then turned around, and not only did they sue the contractor for recovery, but also sued the management company for failing to properly manage the association and allowing this contractor onto the property with this limited language that didn't allow for even the minimal coverage that they had, which was $2 million, by the way, which was, again, a fraction of the total amount ultimately paid out. But they couldn't even get to $2 million because of the language in the contract, and there were some issues. So I think it's a really important, comment you made. You made a lot of great statements in there, it brought up a lot of great issues. I particularly think that as we move forward in the wake of Surfside and the hiring of all these engineers to check the quality of our construction and buildings, to oversee some of these construction projects, it's something to look for in these contracts, because I do know a lot of engineers that were turning jobs down because they did not want to take on the risk or liability, but they are taking on other jobs, and kind of makes you wonder, why are they taking on some and not others? And I would assume, and I haven't seen it yet, full disclosure, but I would assume in some of these contracts with some of these engineering firms, they may have some of that limiting language in there, and it may be something that you need your legal counsel to take a look at. And if they're not bringing that issue up, as Marc is making very clear here, start to look for those things. It's really important for community associations. So let's continue on with this, talking about Surfside, though. I want to talk about best business practices for managers, particularly for property managers. What do you think, in the wake of that, is Surfside and everything else, what do you think is a best business practice for property managers dealing with these types of situations? You brought up pool contractors, which I know is a big hot button issue for you. What is a best business practice in dealing with this? I mean, what is the solution?
Well, in light of all of the issues that associations are facing, the best thing that a manager can do is stay as a manager. Quit being an insurance broker, quit being a lawyer, quit being an inspector. And when their contracts say they're going to come out to the property once a month and inspect for things that are not right, they need to change their contract, because they're not inspectors unless they are. Okay, because if they're a dual professional, then accept dual professionalism. But most, they're managing the needs of the community by pointing the community and the association to what they need. So if they need an engineer, they need an architect, they need an accountant, that's what the manager's job is. The manager should not accept the responsibility of being a jack of all trades, because they will fail. Be about as good as me being a landscaper. Okay, it's just not going to work.
Got it.
And their insurance protects them for management.
Yep.
Their insurance is not going to cover them if they say, well, we went out and we saw some cracks in the driveway, and so we called up the paving company and we spec'd it all out, and they went out and did it. And the management company is outside the scope of their responsibility. It's outside their knowledge scope. And boards hold them to these because the boards don't want to expend those funds. The manager's job is to force them to do it. Now, why would they do that? Well, because they're helping them. The board of directors have liability. Now, they have D&O insurance to take care of some of their nonsense. But if they don't want personal responsibility and personal liability, every state in the country has some form of charitable immunity and liability act. And those acts protect those who act within the scope of their responsibility. And most of them have some kind of limiting language that you have to act in good faith, with ordinary care, and in a manner which you believe to be in the best interest of your entity. Well, those are further limited by some condos which have a fiduciary responsibility. All of those responsibilities relate back to what is a best practice. What's good business judgment? Well, good business judgment is hiring the engineer to do engineering work and hiring the manager to do management work. So if a board decides, well, no, we're not going to hire a reserve study professional or an engineer because we really don't want to know what's going on in our building because we can't afford to do anything. The manager's job is to say, hey, man the torpedoes, butch up. This is what you really need to do. And if you're not willing to do this, we're not willing to work with you.
Right.
And that's what the challenge is.
I think it's stay in your lane, right? Real simple way of saying it. Just stay in your lane. Don't try to be something you're not. We talk about all the time. It's like how many property managers I know try to adjust their own claims, thinking that the representative sent out by the insurance company is working with them, when the person sent by the insurance company legally only represents the interest of the insurance company. It's like, well, if you engage that adjuster in these practices, then essentially you are adjusting the claim. And you're adjusting a claim on behalf of the association, acting as a fiduciary, and decisions and comments and statements you make can and will be used against you in your claim, and ultimately could lead to less coverage and possibly denial, delay, all of which could become at a financial loss or an issue for your community association. So I think it's all really important, and it's really relevant to a lot of the issues we see on the insurance side of stuff. I mean, you said it, don't be your broker, right? I mean, how many managers you ever see, getting so involved and invested in the process of obtaining insurance that they make an assumption that they know what's in the best interest or insurable interest of an association. And it's like, look, that's why you pay a commission to a broker. Allow them to sell the association. Don't get involved in writing an opinion letter to your unit owners or to your owners and the board as to what your opinions are on it, when that's not what matters. It's what the broker says that matters most. So all really, really great issues. So are there, I always, whenever I'm talking with council, community associations, I find that board members particularly and managers love to know about cases and things that they're tracking or just recent opinions. Are there any cases or that are ongoing or recently resolved or potentially proposed legislation in 2022 that you think community association board members and managers should be aware of?
Well, let me go back just 1 second first.
Yeah,
On the management responsibility, did we review the management contract? And I don't want my management people to be mad at me, but the management contracts, for the most part, and I would say over 90% of them, unless regulated by state to say otherwise, say that the association management firm is not responsible for its acts of negligence, only its acts of gross negligence.
Right.
And so it's even more important for them to stay in their lane, okay? Because we don't want them to run the risk of going from one form of negligence to another. Now, on the issue you just raised, extremely important based upon where you are. You're going to have more and more states that are going to pass some legislation as to inspections, especially of the tall buildings. And in the courthouse, what we've seen a ton of is cases dealing with short-term rentals. Yep. People either love them or they hate them. And we've run the gamut. I can't tell you how many cases we've tried on the short-term rental issue. And it really comes down to the wording of the documents. And so sooner or later, I think we'll have legislation on a state-by-state basis. There'll be nothing federal on this, where the states will either regulate, allow, limit, do something. Right now in the state of Texas, we have, I think, 2 or 3 cases that are pending before our Supreme Court, which is our highest court in Texas, where they'll make a ruling. But the problem is all the cases have been decided based upon the wording of the document. Every document's worded a little bit differently. Some documents allow leases, they don't allow commercial activity. is a B&B commercial activity. We have one case that said maybe it's not, maybe it's just residential. So I think we're going to have a lot of shakeout there. It's an interesting area because from a legislative standpoint, the community association will be the smallest lobbyist in the whole process. The Airbnb, VRBO industry is very, very large and very well off financially.
Yeah.
But who is opposed to them is the hospitality industry, because you're taking hotel rooms away from people that take it at Airbnb. And so those will be the behemoths that are fighting each other. And the association will just be there with, it's ping pong paddle while they have Uzis and fighting it all out. So hopefully at the end of the day, it'll be a good result. The negatives on this short-term rental is party houses, okay? And so I rent a 15-bedroom house in a very exclusive community, and then I put it on Facebook that we're having a big party. And, by the time they have the party, it's too late to stop it. And the other is that people tend to not take the neighborhood as respectfully as the owner would.
Right.
And so there's a lot of things that communities are trying to do now. Communities that don't have it in their documents are trying to limit leasing to a minimum period of 6 months. And so that's what the association can do from its side. But then it has to get a supermajority of owners normally to approve the change. So those are two of the things that I think. But the inspection is going to be a debate, a state-by-state debate as to what's required. Certainly, if you would ask me as a lawyer, not an engineer, I would be speculating. I'd say 40 years after original construction to recertify a building seems long. But in some states, including the one I'm sitting in, there is no requirement for renewing certificates of occupancy. So state by state, I think there's going to be something going on there. In our state, the Texas Real Estate Commission is trying to get some kind of a hold on the association industry. This is the first year where they're requiring that management certificates be filed with the Real Estate Commission. So HOA will have to register with the real estate group. And that's the first touch that we've had ever. So I think there's going to be that control issue.
Yeah, and in Florida and several other states in which we operate, you already have a lot of those controls and the costs associated with and the licensing requirements and the certification of board members, and you're starting to see that stuff. So definitely expect more of that in other markets which we operate, like Texas and California and elsewhere. See even more of it. If it doesn't exist, it's probably in the works. Whether it's next year or the year after, I definitely would agree with you tremendously when it comes to those things. You brought up the short-term rentals, and you brought up and now you've brought up the certification stuff. And one thing I think of, it comes to mind obviously real quickly, being insurance coverage experts is, how are these things being insured? And if you do have a short-term rental and you have people in these properties that are only there for the weekend during some big music festival and they're doing things whether illicit or legal, they're not going to treat the elevator cab and the common area hallways and the landscaping the same way as you would an owner. And so that's where you get a lot of controversy. And then where we've seen a lot of issues and lawsuits occur is between owners, one that had the short-term rental and the one that's there full-time. And quiet enjoyment is a thing, right? You're allowed to have quiet enjoyment, and next thing you know, you have that 15-room beautiful house and a massive party in it, and behind the private gate, and no longer so quiet. So there's a lot of changes, and and it's not just an insurance issue. It's just humans being humans. And then you have tragedies such as Surfside that are making major impacts. And I think you brought up a lot of really great points. The whole idea of staying in your lane is a big one. I think some of the proposed legislation is about really solidifying and really putting up walls around those lanes and trying to make sure people stay inside of them. And there's pros and cons of that as well, right? You want to trust and be able to work with others, but a lot of times the legislation may get in the way of your ability to do those things and be that chameleon and kind of help out and move around the association like you would want to otherwise as a property manager or a board member. So really important information. This has been an awesome opportunity to discuss things that are going on in the greater Texas market. As many of our audience know, we recently launched an office there, led by Rob Bowlby. Marc, it's been awesome to have you on. I want to make sure my audience knows how to get in touch with your firm. So website, phone numbers, what's the best way for our audience to be able to communicate with your firm?
The best way is to go through the website, and we have a HubSpot connectivity there to me directly. So if you'll go on rmwbh.com, you'll find all the information about the firm, our principals, our attorneys, our locations, and reach out if you have a question, and we will respond.
That's awesome. Well, hey, Marc, happy holidays to you, your family, to your firm, and all of your associates. It's really a pleasure to meet you, to have you on, talk about really important topics. I feel like we could literally sit here for the next 2 hours talking about some of these things, if not longer. There's a lot to unpack and digest. So again, thank you so much for coming on today.
Thank you. Appreciate it. Have a happy holiday.
You as well. All right. Awesome, right? Great information, really, really important topics. You've heard us preach it here. It's in our marketing materials. It's on our website. We teach CE classes about it. There's always a slide in there about staying in the lane, about not being someone not trying to act as if you know more than what you actually do, or taking on a bigger role, right? There's a contract in place. The community association manager should make sure that they're complying with those contracts, making sure that those things are reviewed as well, because if you're using an old boilerplate community association management contract, it may not be in your best interest, it may not be compliant with the actual guidelines in the state in which you're operating and providing those services. So as Marc mentioned, make sure you're updating those things. This firm is incredibly well respected in the Texas region, so highly recommend reaching out, giving them a shot to take a look at whatever information that you need as a community association manager, board member, or just an interested unit owner. I'm sure they will take the time to walk you through all the important changes that are coming. The changes are not only coming in the Florida, Texas region, New York, New Jersey, it's throughout the entire state. Many of the markets in which we operate, we are seeing people either talk about it or the changes already occur. They happen, some of them on an emergency basis. Some of them are being proposed, so they're going to take several years to work themselves out. Don't want to get caught off guard. You want to have someone like Marc or a firm like theirs in your corner, helping to make sure that you have all the updates and information you can use. And that's why we do this, right? That's what the Recovery Report exists for, to bring on credible people like Marc to talk about important issues that are impacting you as a community association or business owner. So make sure that you continue to tune in. And as you know, we're counting down to 10 years. In March of 2022, 10 years of GlobalPro providing amazing services, proven services to community associations and business owners. Whether it's replacing insurance, to recovering from loss, whether you're rebuilding and strategizing your next acquisition as a multifamily property owner, operator, whatever it may be, insurance is a big line item when it comes to budgets, can impact your cap rates, can impact the management of your property, can impact whether or not your community association has money for those improvement projects. We want to make sure that you have the information you can use, so continue to tune in. Check us out on LinkedIn, YouTube, Facebook, Twitter. We're on all the social media platforms, Instagram, whatever it may be. Like us, follow us on all the social media platforms so you have the information up to date that you need to continue to operate. And we'll see you next week right here, same time, same place on the Recovery Report Live. Thank you again, Marc. Thank you for our audience that have tuned in. We're so happy to have you with us, and a happy holidays.